Disclaimers. In this short video, we will look closely at a particular type of contract term, the disclaimer. A disclaimer is a term providing that a party will not be in breach despite failing to perform one or more of their contractual obligations. For example, when you purchase an airline ticket, there is usually a term in the contract that states that the airline will not be responsible if they lose your luggage. Whether a disclaimer will effectively protect the party from liability for breach of contract depends upon two things. First of all, whether the disclaimer is in fact a term of the contract, and secondly, whether the disclaimer will be interpreted as applying to the particular breach in question. While many businesses will often insist that they are protected by a disclaimer, we should not assume that that disclaimer is legally effective, and we should consider each of these two questions. So the first question is whether or not the disclaimer is really a term of the contract. A disclaimer will only be a term of the contract if it is included in a signed written agreement, or it was brought to the other party's attention by reasonable notice before the contract was formed, and refer here back to the case of Ollie and Marlborough Court, or it is implied into the contract as a result of prior dealings, and here refer back to the Balmain New Ferry Company case. The second question is whether or not the disclaimer, even if it is a term of the contract, is going to be legally effective and apply to the particular situation. If the disclaimer is contained in a contract with another business, the courts will presume that the parties had equivalent bargaining power and will interpret the disclaimer neutrally and without favoring either party. They will simply apply the rules of interpretation that we considered back in topic 3. However, if the disclaimer is contained in a contract with a consumer, the court will interpret the disclaimer contra proferentum, which means that it will be interpreted against the interests of the party seeking to rely upon the disclaimer, which will usually be the business. The reason why the courts take this approach is because the courts are very much aware that when a consumer signs or enters into a contract with a business that contains a disclaimer protecting the business, it's not because the customer willingly chose that disclaimer or willingly agreed to its inclusion, but it's because the consumer usually had no choice. So for example, when you buy an airline ticket, if you were to ask the airline to remove the disclaimer that protects them from liability if they lose your luggage, the airline would of course more than likely refuse to do that. And if you then refused to fly with that airline and went and tried to buy an airline ticket from another airline and then asked that other airline the same thing to remove the disclaimer from the contract, they of course would refuse as well, and you would not even have the option of flying with any airline. So we agree to the inclusion of these standard disclaimers in these sorts of contracts because we really have no choice. And as I said, the courts are aware of that. So when the courts are called upon to interpret a disclaimer that is set out within a consumer contract, they will generally tend to favor the interpretation that favors the consumer rather than favors the business. An example of this is White and John Warwick from 1953. This is a case involving a contract for the hire of a bicycle. Mr. White hired a bicycle from John Warwick & Co. He signed a written contract when he hired the bicycle. Unfortunately, the bicycle wasn't properly maintained, it was faulty, and when it broke, he crashed the bicycle and he was injured. When he asked for compensation from John Warwick & Co. for their carelessness, John Warwick & Co. pointed to a term in the written and signed contract that stated that nothing in this agreement shall render the owners liable for any personal injuries to the riders of the machines hired. The court explained that there were at least two possible interpretations of this particular disclaimer. One was that it related to only those personal injuries that were caused by the rider's own carelessness, and the alternative interpretation was that it applied to any injuries, however they were caused, whether they were caused by the rider's carelessness or whether they were caused by the company's carelessness. The court said given that there are at least two possible interpretations, they would interpret the disclaimer contra proferendum, or against the interests of the company, and they therefore favored the interpretation that limited the operation of the disclaimer to those injuries that were caused by the rider's own carelessness. So in this case, because the injuries were caused by the company's carelessness, the disclaimer did not apply to that situation, and Mr. White was entitled to compensation.